Hey, welcome back. Well, for years, Nassau County's been paying out tens of millions of dollars in refunds to commercial property owners who challenged their property tax bill. Then in 2013, Nassau County legislators greatly increased penalties to businesses that did not file the required income and expense statements that the county was demanding each year. At one point, County Executive Ed Mangano included millions in projected revenue to try to balance the county's budget deficit. But a state agency ruled the revenue could not be included because of a legal battle with 1,000 property owners and businesses. And that's where our next guest comes in. She is Lorene Harris, a Nassau County tax attorney and one of a team of attorneys that recently scored a legal victory, a big legal victory against the county. And welcome to the show.
Thank you.
First of all, explain your victory.
The recent victory, our law firm, Cronin, Harris & O'Brien, has been challenging this law since February of 2014. We challenged the law and the amendment. It was actually an amendment to the law requiring income and expense statements. Requiring income and expense statements has been around since 1984. In 2013, what they did, and I have to underscore this, is they egregiously increased the penalties.
Give me an example.
If you file your statement and it's illegible, you can, under this law, and actually in practice it recently happened, you can get a penalty for failing to state a line or it's illegible. Any mistake, a minor mistake, can cost a property owner $250,000 added to their tax lien.
How in the world would it go to $250,000? Basically,
the law says that if you fail to file, okay, which it includes not just filing income and expense, it includes if you fail to file electronically on the proper form, a lot of technical things, if it's illegible, if you miss an accounting period.
This used to be a $500 fine. You're saying it went from $500 to $250,000? Is that the extreme example you're quoting?
No, yes, it is a higher example. However,
like
let me take
big,
the small
giant business that would be paying
a shopping
big
center.
Money in property
Typical
taxes
shopping
anyway?
center, actually, is what I'm talking about.
All right.
The smaller property owner.
What would be more typical kind of penalty that you're talking about?
Well, not typical, but there would be, for a smaller property owner, let's say a Subway and a nail salon sort of thing, a smaller property owner, a penalty would often be $8,000 to $10,000.
So what did the judge decide?
The judge has decided several things over the last 3 years, but most recently, the judge declared that the temporary restraining order that we had in place since August of 2017, because the judge felt that the law violated the commercial property owners, was concerned that the application of this law would violate the commercial property owners' due process rights, both in notice and an opportunity to be heard.
Rights.
Right, and would impose the penalty without those rights. And that's precisely what happened.
So all of that's still yet to be determined.
Whether or not the law itself violates both excessive penalties clause, as I just said to you, what could be an example, coupled with no notice, so they were blindsided. Because
some of this money would have been applied coming February 10th, right?
Any penalties become automatic tax liens. So we've all done
the property, and that would have been in early February. And there's going to be a hearing ahead of that.
Correct.
But let's go back a little bit. The presiding officer for the Nassau County, Norma Gonzalez, she says these lawsuits are unnecessary because there'd be no penalties if the businesses would simply file the statements that they have in their possession. Why not file them? Why have some not filed them?
That's 1,000% incorrect.
Well, how so?
Very easily, because as I stated, we've been challenging this law since 2014. Very early on, we had an agreement with the county that we have no prohibition from the county receiving all income and expense statements. What we're challenging is the imposition of the penalty.
So it's strictly the penalties.
Correct.
Because they, but why not file anyway? Because the county says, look, it's not fair what you're doing here because we get inaccurate information that we're, this system, we all know a lot of times there's guesswork involved, and then it's wildly off. They make these big refunds that they have to borrow money against, and the taxpayer gets stuck with the bill. They're saying if these businesses would give us accurate information of what they're really making, what their expenses are, we could make a correct property tax assessment. And then that would, there wouldn't be the big burden on taxpayers that we see every year. They borrow tens of millions of dollars every year.
That's just a non-issue, because taxpayers have been complying. Now, let me give you an example that that was given to the legislature about 3 weeks ago, okay, when it was discussing what's called the amnesty provision. The individual who was in charge of income and expense statements for the county stated that in 2008, when the penalty was $500, they had an 82% compliance. What we're really challenging here is that the disproportionate, egregious penalties that become automatic tax lien violates the protection of the commercial property owner.
Well, you know, this is a huge debate. Newsday, they had an editorial just a few days ago saying that you kind of have a conflict of interest because, you know, this is a broken system, and instead you'd rather sue and maintain a system where information is not provided and refunds occur, because when you get these big refunds for your clients, you get a big fee.
Well, it's a couple of things about that, right? The system is not so broken as it's unsustainable. I can leave that for the moment, okay? Number two is, for challenging this law since February 14, we have not charged one legal fee. The problem
not the law, so we're talking about when you get them property
when
tax
I challenge
refunds,
when our law firm challenges the assessed valuations and win, isn't it kind of crazy to blame the firemen for the fire?
Well, what they are.
Doesn't make any sense.
Because, you know, everybody's pointing fingers.
I guess that's what they're relegated to answer.
The assessment system in Nassau County, it's defied reform, and it has never delivered.
If I can answer that, I'm not so sure that the system in Nassau County, in terms of the assessed valuations, which is between 400 and 500,000 parcels, they have to get the fair market value right every year. Very unusual throughout New York State to have that many for the assessor to get right. The real problem is, okay, that Nassau County is saddled with paying, as you had said in your introduction, with 100% of the refunds. So they have,
that's a separate issue, that they get stuck with everybody's refund.
For them,
that's an issue they've got to resolve.
That's the issue, which results, with all due respect, that's what results in them looking for money because they're behind the 8 ball, the county, every year.
Well, this is going to go on, and we'll be hearing on February 8th. We'll see what the judge rules in this years-long legal battle between commercial property owners, with the help of their attorneys, and Nassau County legislature and administration. Lorene Harris, thanks for the update on this.
Thank you for having me.
And we'll